Spiel and you've preserved your record, you now have a viable issue on appeal. Once the judge names all those people in front of 6 or 12 people, the judge is going to turn to you and say, are there any objections to these people who are going to decide your client's fate? The knee-jerk reaction is to say, no, Your Honor, these are great. If you do that, you are waiving your issue, even if you have already perfectly preserved it. I typically respond in that point, Your Honor, I re-urge my prior motions, and he'll say denied, and then you're good to go. But if you say no, appeals courts love it when lawyers say no objection to something that they've already objected to because they're waiving the issue, and it's certainly easier than dealing with it on the merits. All right, so I'm going to give a couple of examples of voir dire stuff that I have found useful. A warning here, don't treat this as a script. Don't treat this as a script. Don't treat this as a script. These will be in the materials that are going to be in the Dropbox. They're not in the Dropbox yet. I had some emailing issues. I'm on the road this week. Don't use it as a script. If you try to use it as a script when it doesn't play out exactly the way you want it to, you're going to be standing there embarrassed, and the jury is going to be sitting there looking at you like, what is this guy talking about? Get familiar with it, though, so that you can have a conversation with the jury that you're guiding sort of using these principles. So, as I've told you, most of my trial experience has been in DWIs. In the modern day, the hardest thing to overcome on a DWI is that every person in the room has been taught and has taught their children, don't drink and drive. Don't drink and drive. Your defendant almost certainly has confessed to drinking and driving. That's not the issue. The issue is whether they're intoxicated. You've got to overcome a cop who is going to take the stand, testify, I smelled alcohol on his breath, I did these field sobriety tests on him, I thought he was intoxicated, and so I arrested him. That's not really what happened, though. I will find, and this is one of the times that having the jury questionnaire is really helpful, and I'm going to pick on Ross here because I know he does, but I will find someone who has a teenage child, preferably a son, if it's come up that that person has a son, and I'll ask, Mr. Palmy, I'd like you to imagine that someone has shown up at your home to pick up your child and give them a ride somewhere. And as you're talking to him at the door, you catch just a very mild odor of alcohol on their breath. From that point forward, how sure do you need to be that that person is sober before your kid can get in that car? Right, you're going to set a near impossible standard, right? But we can agree that the answer is completely sure that that person is sober before my kid can ride with them, right? Well, and then I would bounce to somebody else. What is a police officer's number one function when he's out on patrol? What's he out there to do? I'm sorry? Okay, that's something that a lot of them probably do a lot of, but why do we have him out there? Yeah, to keep us safe, right? All right, so now imagine that you're a police officer and you've encountered a driver that's got alcohol on his breath. How sure are you going to need to be that that guy is sober before you'll put him back behind the wheel again? 100%. Yeah. How much daylight do you think there is between that officer's standard and Mr. Palmy's standard? Probably not a lot, right? And so, I mean, can we all agree, though, that as citizens of this community, if an officer encounters a driver who's been drinking, we'd all kind of like him to just get that guy off the road, and we'll figure out later whether he actually committed a crime or not. I mean, is there anybody here that thinks that there should be a different standard from that? All right. At the end of that discussion, almost everyone in the room is thinking, oh shit, if I get pulled over and I've got alcohol on my breath, I am not driving home. And you know what? That's cool. I have kids, we drive, I don't want to share my road with drunks. Now that and this is completely true, now that I am a parent, I have no interest in sharing my road with drunks. They're dangerous, they do terrible things, they do stupid and unpredictable things, and I am okay with a rule that says if a cop encounters you with alcohol on your breath and you're behind the wheel, you're done. He's going to take you down, and we wind up in court. I found that to be very effective. It also, kind of going hand in hand with that, is every person in this room has an absolute rule for their minor children. If I catch you drinking and driving, I don't care if you're drunk or not. I don't care if you're drunk or not. If I catch you drinking and driving, it's going to be a real bad night, right? Is there anybody in here that has a different rule for their teenage kids? Of course not. It was the rule I was raised with. Now, when I got to college and to law school, I'm not going to say that I obeyed that rule, but one of the impediments that you're up against in a DWI is that culture has changed in this country. I was in high school when the open container law passed, and I remember how controversial it was, and I couldn't understand why it was controversial. But the reason that it is, aside from speeding, it's the only other non-arrest offense is because that was the compromise that had to be made to get it through the Texas legislature 20 years ago. In those 20 years, attitudes have changed. The jury needs some reason to believe that this cop arrested your client for DWI, but he's not guilty. How is that even possible? Well, because the rule is the cop's got to be 100% sure that he's sober or he's going to get arrested. And at the end of the day, most of us are okay with that rule. Okay. So, and this one is also related to the fact that on a DWI, on almost every case, your client has given a partial confession. Your client has confessed to drinking and driving. And so when we talk about the presumption of innocence, it's really hard to get jurors to agree that we're going to start from zero and truly presume that the guy was sober and make them prove otherwise. So, all right, can I get a volunteer? Anybody? Volunteer? Okay. All right. I'd like you to imagine, and this is silly, but I need you to go with me here, okay? I would like you to imagine that the cereal lobby has gotten to our legislature, and our legislature has made it illegal to eat eggs for breakfast. Now, they couldn't get the votes to illegalize eggs altogether. You can still bake with them, you can still eat them for lunch or dinner, but not prior to 10 in the morning, okay? Now I'd like you to imagine that you get a knock on the door and there's a detective there, and he says, "Sir, we did a trash pull in your neighborhood this week, and we found eggshells in your trash can, and so we need to have a talk." And you find yourself dealing with the detective, trying to convince him that you didn't eat eggs for breakfast. What sort of evidence would you want to give him?
Check my trash. What I actually had.
Okay.
What I actually had.
All right, what is that?
Sure.
Okay, well, what's your evidence for that?
Call it bluff.
Okay. Jury, are we buying it? Is he there yet? Okay. What other sort of evidence might you want to bring if a detective's accused? I'm sorry. What other evidence do you think you might want to try to give this detective to show that you didn't eat eggs for breakfast?
Dirty dishes.
Okay, dirty dishes. Great. But, I mean, if there's eggs on those dishes, I don't see how that helps you. Okay. What else?
My refrigerator. No eggs in the refrigerator.
Well, right, because I found them in your trash can. All right, usually at this point somebody will say, well, I could bring in a coworker to talk about the cake that I brought to work, and they will start giving you ways that you could prove your innocence. And then I find somebody who lives alone. Anybody? All right, Mr. DuPont. Do you feel like if you needed to prove that you didn't eat eggs for breakfast, do you feel like you might be at a disadvantage compared to the guy sitting next to you that has a house full of kids? Okay. Does anybody here feel that it would be fair to make Mr. DuPont provide the same sort of evidence that somebody that lives with other people could provide? If I set out to, do you think that I could actually prove to you that I didn't eat eggs for breakfast today? No, probably not, right? And that's why our system is the reverse of that. You have to start from the position that I didn't eat eggs for breakfast and demand evidence that they did. I guess all I can say is trust me when I tell you it works better in court. It usually, so I've heard varying themes on using humor in voir dire. I use humor in every voir dire I do. I was that awkward kid growing up that discovered fairly quickly that if you could get them to laugh with you, that they would make less fun of you, and that people like you when you make them laugh. And I think that applies in voir dire too. If you can get the group laughing, it tells you two things. Number one, they're listening to you, and number two, they don't hate you anymore. One of the reasons, though, that I use that is my default position is my clients don't testify. I need to find a particularized reason that person would need to testify before I'm going to advise them to testify. And so in nearly every voir dire, you've got to cover the Fifth Amendment. But let me ask you, if you ask your kid something about the broken vase and he tells you that he doesn't want to answer any questions, do you need to ask any more questions? No, right? We're going to ask the jury to not only tolerate, but to accept something that they would never, ever, ever tolerate from their own kids. And so the way I set that up is I ask everybody, first, close your eyes for just a second. All right? I promise I'm going to be standing right here when you open them. This isn't going to be that weird. And I'd like you to think back to the most humiliating moment of your life. And just kind of sit there for a second. Okay. Now that you're there, is there anybody here who would like to volunteer to take the stand and allow the prosecutor and I to ask you any question that we want to ask you about your humiliation? And you're under oath to answer that question fully and truthfully. Any volunteers? And I usually won't get anybody. And if you add to that whether or not the people listening to your story believe your story completely is going to determine what the rest of your life looks like, would you be more or less nervous knowing that? Yeah. How relieved would you be if someone leaned over to you and says, hey, don't worry about it, you don't need to do that? Okay. Now, sir, and I'm sorry I've forgotten your name. Lloyd. I'd like you to imagine that officer was not convinced by your spiel on the eggs, and we find ourselves in trial, and I'm representing you. The government gets to the end of their case, and I lean over to you and I tell you, Lloyd, they haven't met their burden. They haven't proven their case. It's your call. It's your decision, but I don't think you should testify. I don't see any reason for you to relive that humiliation. Do you think you would take my advice or take the stand?
Take your advice.
Okay. How many of us agree? If the lawyer says don't testify, then don't testify. Okay. Now, how many of us disagree? How many of us feel like, look, if I'm innocent, no lawyer, no nothing is going to keep me off the stand to tell my story? How many of us feel that way? You'll get a hand or two. Okay. I'm with you. If I was innocent and accused of something terrible, I don't know that you could keep me off the stand. And I'll shoot you straight. As a lawyer, I feel like I could handle myself on the stand better than a civilian might, because I think I would have a better idea of what's coming. I'm not going to ask you to change your mind, but I do need to ask one thing of you. You saw when I asked those questions a minute ago that the gross majority of the people on this jury with you would take their lawyer's advice and not testify, right? I mean, you saw that that's what they're saying. So the one promise that I need to get from you is that if at the end of this trial I advise Mr. Smith not to testify and he takes my advice, can you promise to give him the same benefit of the doubt that you would give the rest of these people and take nothing more from that than he's listening to his lawyer? Is that a promise you can make? Okay, thank you. Thank you. Is there anybody here that feels like, you know what, I don't know that I can make that promise. I feel so strongly about this that I might read something into that. For the most part, look, like I've been saying, you can't change these people's minds. The most you can hope for is to get them to out themselves if they're going to be terrible jurors or change how they look at a situation. Once you point out that even though it's his call, I'm the one whispering in his ear, and that most of the people in the room would do whatever I'm telling them to do, then now, if you do that, you have to make sure that you don't just stand up and rest right behind the state. You do have to lean over and tell your client, hey, I don't think they've proven their case. I don't see any reason for you to testify. It's your call. What do you want to do? And have your client trained to say, I don't want to testify. All right, Your Honor, the defense rests. And then at that point, your worst case scenario is there's one or two guys over there that are suspicious, but you've already made them promise on the record under oath that they would give your guy the same benefit of the doubt that they would give these other people who they actually like. That's the other thing to remember, is that by the time you stand up in voir dire, these people have formed something of a group. They largely like each other. There are some people in the group that they don't like, but it's like your little brother. They can beat up on him. You'd better not. So that kind of gets us to the end. I will have those examples that I gave you in the handout. And what questions do you got? Do we have time for questions? We got like a minute and a half by my count. What questions do y'all have? Yes, sir. Oh, I couldn't find the video. This is Dave Chappelle testifying before Congress, only he won't testify. Every time they start to ask him a question, he says, fifth. Fifth. Yeah. And he's got this, he does a whole long spiel, and then the senator starts to ask a question. It's, sir, fifth, five. Yes, sir. Yes, so on preserving error.
All of that, all of the arguments should probably be done outside the court of jury.
In Harris County, typically this happens in a bench conference, has been my experience. But that bench conference where you guys are fighting back and forth over, well, no, the jury, and I would argue that if the judge, right, I would argue that the judge trying to make you do any of this in front of the jury would be error in and of itself. I mean, this is definitely something you should approach on. Now, the problem is that the first 2 and maybe 3 steps will happen at that initial bench conference. Then everybody goes back to